Testing 1, 2, 3. Testing 1, 2, 3. Check, check. Testing, testing.
Morning, everyone. I'm Chief David Zabalski of the Fargo Police Department. I'd like to introduce a couple of my colleagues to you, Sheriff Jesse Johnner from Cass County and Sheriff Dennis Otternis from West Fargo PD. I'd also like to thank our partners and friends at the Downtown Community Partnership, the Chamber, and the Business Improvement District. One thing that the three of us have done in actually a short period of time is form a very solid partnership in terms of public safety coalitions and collegiate relationships. And we all have a very strong belief in the importance of educating the public about issues that come to our attention or to your attention so that we can improve public safety across the board. So this morning's presentation is just that. It's an opportunity for us to better educate you about certain things that happen in the criminal justice system. And we're also going to talk about this proposed bill that may have some adverse effects on the current process. So we're not here from a political perspective, we're here from a public education perspective. And so we've got about 30, 40 minutes of presentation, and we've left 20 minutes at least on the end to take questions from our business community partners. We feel that this particular bill has great effect not only on the community at large, but also those of you in the business community. So I'm going to turn it over to Sheriff Johnner.
Thank you, Chief. And I'd just like to add real quick to his welcome. Anytime that we can get together, us as law enforcement, then also with our business community and our citizens, is a great opportunity for us. And we really appreciate you guys taking the time to come in and spend some time with us this morning. So I'll get started here. Just real quick, so everyone kind of understands the difference between the sheriff's office and the police department. First, my position is an elected position, and so I'm voted into my position by the people and work directly for you guys. The main duties of the sheriff, of course, is to provide public safety, keep the peace, civil process, bring fugitives before a magistrate. We have approximately 230 employees, 120 of which work in our jail, and our jurisdiction expands 1,768 square miles and includes 27 cities. Just real quick with our jurisdiction, oftentimes you guys don't see us downtown a lot. Our jurisdiction is whole Cass County, and typically we focus our enforcement efforts out in the county area because they don't have a lot of law enforcement out there. So, but typically if Fargo Police Department or West Fargo Police Department needs assistance in taking calls for service during major incidents and things like that, then we'll come into town and assist them at that point. As the sheriff, I oversee the jail, and our jail capacity is 348. And kind of how the jail works is people that are on pretrial waiting to go to court are housed at our Cass County Jail. And if an individual gets sentenced to a year and a day, then they go out to the state penitentiary. All right. Just some real quick differences between the sheriff's office and city police as far as ordinances, which becomes important to what we're talking about today. And that is the police department, they enforce city ordinances. And as the sheriff's department, we enforce state law. And so if we come into the city to assist with enforcement efforts, we can't enforce city ordinances. We just work off of state law. And then, of course, we're going to have different bond schedules. So that's going to kind of become important here in just a few minutes when I explain how bond works for misdemeanor arrests. So different bond schedules are set. As far as the city is concerned, they have a municipal judge and work off of municipal ordinances. And then everything that we do at the sheriff's office goes into district court or state court through our district judges. All right, so why are we here this morning? Very much like Chief Cebulski said, is really just an educational piece to educate our business owners, our citizens on House Bill 1123. And I took part in your guys' meeting this fall when you had some issues that came up with the downtown business district. And I very much appreciated being invited to that because this needs to be a collaborative effort. In sitting through that meeting, I realized that there were a lot of issues that you guys are working through in the downtown area and certainly want to assist in that effort. And so I feel as the sheriff that this bill could have some potential effects on some of those enforcement efforts. So House Bill 1123, this is what it says. Admission to bail is the order of a competent court or magistrate that the defendant be discharged from actual custody upon undertaking with sufficient sureties for the defendant's appearance, except as otherwise prohibited by law or in case involving offense under section 12.1-1701.2, a resident of the state arrested with or without a warrant for a misdemeanor offense must be released from custody on that person's own recognizance, without appearing before a magistrate. In a misdemeanor arrest warrant, a magistrate may order the posting of bail if the magistrate has reasonable and probable grounds to believe an individual will disregard a written promise to appear under the subsection. And then the last point here, any magistrate or municipal judge in this state may designate, authorize, or appoint an additional person or persons to arrange, receive, and approve forward that bail. So this is the misdemeanor portion. That's the portion that I'm going to focus on. And Chief Cebulski will go into a little bit more depth about the felony portion of this bill. So as just kind of a brief summary, basically says that if law enforcement comes into contact with these individuals, they can cite and release them on scene to their own recognizance, which means that they would give them a court date. That person would promise to come back to that court date, and then they could be released. The other option to this bill is we could still arrest that person and remove them from the scene. But when we take them to the Cass County Jail, then they would immediately be released without having to post a bail or bond. So that would be the highlights of the bill, so to speak. So let's talk about what misdemeanor offenses are and what we currently do with those. So everyone's probably heard of an infraction. An infraction is a traffic offense that you obviously commit when you're operating your motor vehicle. Then we go into Class B misdemeanor. That's going to be your next offense after an infraction, and that's punishable for up to 30 days, no more than $1,000 in fines or both. And then I listed some of the some examples of Class misdemeanor offenses: theft 0 to 500, disorderly conduct, simple assault, harassment, criminal trespass if given a notice. So those are just some examples. Class A misdemeanor is a step up higher from a Class B misdemeanor, and that's punishable up to 1 year in jail, 2,000 or both. And some examples of those, as you can see, assault, criminal trespass, engaging in a riot. And then it jumps up to our felony classes, and Class C felony are those thefts exceeding $1,000 to $10,000 or both, and that's going to be your aggravated assaults with serious bodily injury or terrorizing. And then it gets into our Class B, Class A, and Class AA felonies, which are more serious offenses. Okay, so misdemeanors currently. An officer cannot make a misdemeanor arrest if the offense does not happen in their presence. There's a few exceptions to that rule. Those would be domestic violence, order of protection violations, and some DUI circumstances. That's a few of the examples. But other than that, misdemeanors, officers can't arrest unless the misdemeanor happens in their presence. Okay, so then you ask, well, what happens if someone witnesses someone committing a misdemeanor offense? What could we do in that case? What you can do in that case is obviously certainly call law enforcement to still come to the scene. When we come to the scene, we would take a report from you, gather your information on what you witnessed or what you saw that had occurred. We would then complete a report at that point, and we would forward that report to the state's attorney's office. And if the state's attorney's office felt that there was enough probable cause through your witness statements and through the information that you provided, then an arrest warrant would be issued, and then we would go look for that person on the arrest warrant and bring them into jail. Does that make sense? If you guys have any questions while I'm going through this, please ask me. I know sometimes it gets a little confusing. So that's how that would work. We talked about the misdemeanor arrest exceptions already. So this becomes important with this bill because currently these are misdemeanors where the person must appear and there's no bond set for that person. And so if we look at this real quick, it just says any misdemeanor involving violence, injury, or violation of court. So your simple assaults, domestic violence, violence of protection order, failure to register as a sex offender, or any misdemeanor which obstructs law enforcement, false information, hindering law enforcement, resisting arrest, preventing or obstruction of law enforcement, eluding a police officer. So currently these particular misdemeanors, if we make arrest on those individuals are taken to the jail and they have to see the judge. There's no bail for these offenses, okay? With House Bill 1123, that would no longer be the case other than the domestic violence that's listed in there. The other ones, they would be released on their own recognizance. So that, of course, is a concern for us because some of these are obviously violent offenses, and our concern is that this person would be arrested, brought to the jail, and immediately released and could go back into the community before talking with the judge to determine why they were committing the acts that they were committing. Okay, so is there any questions up to this point on misdemeanor arrests or how we handle those situations, exceptions? All right, so what happens after the arrest? If that person has some sort of a medical condition, if they're under the influence of some narcotics or alcohol, they're taken to a local medical facility where they are cleared, and then after that, they're brought to the Cass County Jail. I think everyone knows this, but there only is one jail. It's the Cass County Jail, and that's where Fargo Police, West Fargo, everyone brings their in custodies to. Once that person is brought to our jail, of course, we gather booking information from them. Mugshots are taken, they're fingerprinted. We then, if there's a victim involved in it, we would put that victim's information in a program called SAVIN, and that's a statewide program. And what that program is that notifies the victim when the suspect is released from custody at the jail. It notifies the victim that person's going to be released. Okay, and then typically right now they would forfeit a bond, and a court date would be given to them. If they post that bond, they would be released from jail and then would have to come back at a different time and go to court. Okay. If they don't post bond and they decide to stay in jail, then typically they see the judge. Could be the same day, but most likely it's usually the next day, and a lot of them are appearing by ITV court right now. So this is why I opposed the bill or provided testimony in opposition of the bill. Number one, as we call it, catch and release, and that is where we simply come in contact with that person that's committed an offense. We write them a citation and release them on their own recognizance. And unfortunately, we've had a good opportunity to see or work through that situation right now with COVID. because not everyone is being brought into our jail currently if they have a misdemeanor charge, and that is because of isolation efforts that we're doing at the jail to try to keep the jail safe from COVID. So we've had a good opportunity to see if this works over the last several months. And so what we found is that in my opinion, it has not been working. Currently, we have 3,200 outstanding misdemeanor warrants right now in Cass County. That's a lot. And a majority of those warrants are from people that were initially came into contact with law enforcement, were given a court date, and just didn't show up for court. So that's my fear with, as we continue down this road, is that we're going to get more and more outstanding warrants that need to be taken care of. Of course, public safety is our huge concern. That's all of our, whether it's Chief Otterness, Chief Cebulski, or myself, our number one concern for our community is public safety. We want to make sure that our citizens are safe, that our businesses are safe. That's always going to be our number one concern. Doing the catch and release can sometimes tie up officers longer, especially if it's a DUI, DUS charge, because at that point, the officer is probably going to sit with the suspect until they have someone come and get them. Because if we cite someone for a DUS or driving under suspension, if we cite them and release them and just leave, there's a fear that they might get back in the car and drive again. So typically we'll wait for a ride to come and pick them up. That takes officers off the street for a period of time while they're waiting. The same with DUIs. If that person's intoxicated and release them, obviously we do not want them to get back in their car and drive, and so we're going to wait for someone to come and pick them up. There tends to be a high chance of recidivism, like I just mentioned, with, we have the outstanding warrants, people going back to their activity that they were doing prior to coming into contact with law enforcement. This is probably the biggest one for me because I sit as a board member on the Crime Victim Services Board, and there's a lot of focus on this bill on the offender and not the victim. And so at some point, we need to stand up for our victims, and I'm very much an advocate for that. I do want to help offenders when they get in trouble. We have people that make mistakes, and when they make mistakes that first or second time, certainly we want to get them back on the right track to becoming a successful citizen in our community. But for the time being, when they're committing that offense, the number one priority is the victim. Did we serve that victim appropriately and bring justice for that victim? 90% of the people, and where I'm gathering these statistics from, are from the jail. I've got obviously very good access to the statistics in the jail, so I feel that the statistics that I'm giving you are very much on par, are very accurate. 90% of those arrested on misdemeanors in Cass County make their bond. So it's not like we have a bunch of people sitting in jail waiting to get out. There are a few. Some of those are, it's by their choice. Some of them are have to sit in there because they're repeat offenders. Even though they have a misdemeanor charge, they've maybe committed several misdemeanors over the past year, and so they need to sit in there and talk to the judge about it. In doing checking on bonds in the area, we have some of the lowest bonds in, whether it's in South Dakota, Montana, Minnesota. I've checked with a lot of the bigger cities there, and our bonds are some of the lowest. Okay? And then the bond that is collected if those individuals have to post the bond is maintained in the court system. It's used to pay for court fees. It's also used to provide restitution to the victim if restitution is needed. And so that's the piece that I feel we would be missing. And I just have a sense that if someone has to post bail or bond, they have buy-in into the process. Like any of us, if you pay money to someone, you usually want to see that through and make sure that it gets used for something that's going to assist you. So there's a buy-in to posting that bail, in my opinion. So what are we currently doing to work with offenders? And this is my last slide here, and then I'll wrap it up and turn it over to Chief Cebulski. We have what's called a community supervision unit. And so, I don't want people to think that my idea is to just arrest everyone and just simply put them in jail. I've at the Cass County Sheriff's Office, I feel like we do a really good job to try to already rehabilitate people and make them or help them become successful citizens. We run a community supervision unit which has availability for 45 individuals. And what it is we allow people, if they're on pretrial and their bond is $500 or less, and there's no safety risk to the community, they can go out on community supervision. They can still get the services, the rehabilitations, whether it's addiction, chemical dependency, services that they need to rehabilitate during that time, but they can stay at home and they're not at the Cass County Jail. That does a number of things for us. Number one, it's fiscally responsible to the taxpayers. It allows that person to continue to work their job and not lose their job. And so this program has been very successful. We've had people contact us nationwide to try to determine how we do this. I have 2 deputies that all they do all day long is go and check on these individuals while they're on this program to make sure that they're following the rules, abiding by the law and stuff like that. Okay, so that's kind of just an idea of some of the things we do. So just as to sum it up real quick here, basically what this bill would do is it would allow officers to cite and release on their own, release the person on their own recognizance, which we can already do, okay? So we could either do it on scene, or that person could be arrested and taken from the scene and taken to the jail, but there would be no bail required of these individuals. So that's where the difference is, okay? Does anyone have any questions for me before I turn this over? I'd be happy to ask and answer any. Yes? Sure. So the main issue, as I remember, that was brought up, or I shouldn't say issue, the main point in them bringing this forward was simply that they were concerned that the offender would be sitting in jail for a number of days and not be able to make their bond or their bail. And in having to do that, they would lose their jobs and would really have a hard time once they got out of jail turning their life back in the right direction by having to look for a job again, trying to pay those fees off now that they don't have a job. I think that was the main focus behind it. So I don't know if there was anything else, Chief Sapolsky, that you remember that was brought up. Okay. So any other questions for me at all? Again, thanks for coming and participating in this.
Okay, thanks, Sheriff. We are getting some questions in through Melissa Brandt, so if you're watching this live streamed, you have some questions, you can send them to Melissa, and she will text them up to this, and we will address those at the end. So, as you can see, you got kind of an overview of what the current situation is in terms of our ability to arrest. We have to, if it's a misdemeanor, it has to occur in our presence, absent a drunk driving or domestic violence offense. All of those cases allow for law enforcement to take that individual to the Cass County Jail if they are being aggressive or they're being repetitive in their actions. So something like a disorderly conduct fight downtown is not something we would cite and release because unless the individual brought themselves under control, because they're likely to re-engage in that conduct. Just like someone attempting to incite a riot, from a misdemeanor perspective, we could arrest and book them, and they would either post significant bail or see the judge the next day. Under this bill, they would be freed after booking to re-engage in that conduct. So what does this bill do? Excellent question. Okay, so legislative intent, and I want to mention that I think the legislative delegation that brought this bill forward, I believe, was well-intentioned in what they were trying to do. So if you follow the national story on bail reform, which is not anything new. This has been going on since Ferguson in 2015, where one of the issues that came out of that review was, Ferguson PD basically supported their budget on fines and fees that were put in place for during traffic stops, ordinance violations, et cetera. So they had an incentive to write those tickets. Most of the people who received those fines and fees had low socioeconomic status, weren't likely to pay them, ended up with warrants, and then ended up sitting in jail for failure to pay a fine. So I don't think anyone disputes that that's not a good outcome from a criminal justice perspective or for the persons involved. So their intent is, a large message is, they want to eliminate wealth as a determiner of who gets out of jail. And they'd say, look, because I'm poor, but I am not at risk of reoffending or committing other crimes, I'm not a danger to the public. The fact that I can't post $100 and get out of jail, that shouldn't be a determinant. It should be whether or not I will come back to court and whether or not I'm not going to further endanger other people in the public. As the sheriff mentioned, there are some instances nationally you could look at, and people have lost jobs and had other bad outcomes because of that. So that's not an issue that we would necessarily disagree with. They also want to fix the issue of money-based bail to avoid potential civil litigation. So constitutionally, there is an argument that money-based bail is an issue. That's come up in other states, and some states have taken very proactive, reasonable measures based on evidence-based research to address those issues, and I'm going to talk about that in a little bit. Some states have just walked away and said no bail. Perfect example, look at New York. In New York right now, I can commit a robbery, I'll get arrested, I'll get booked, I'll walk right back out the door, I can commit another robbery. And this has happened. They have people that are being arrested continually for the same crimes, but because there is no ability to control their behavior, and they are a danger to the public, and they won't appear in court, the approach taken in New York places their community at extremely unnecessary risk. In fact, we just watched a video last night on TV in New York where a large mob chased a guy down and just beat him to a pulp a couple blocks from their city hall. So the importance of, while this is well-intentioned, the importance of doing this the right way, that's where public safety comes in, and that's where all of you need to be educated about this. And we're going to talk about what you need to know here in a bit. Creating a fairer judicial system, I don't think anyone would argue with that. My law enforcement colleagues would look at all of these points and go, these are probably good ideas that we could get behind in a collaborative coalition type fashion. Unfortunately, that's not what this bill does. Now, while we have talked to some of our legislators who sponsored this bill since its initial submission and since our testimony on January 18th, the sheriff and myself talked to a couple of them. They're working on some revisions, but again, when we give you the education piece, you'll see that the important components still aren't there, and that's what we need to have. So the bill as written incorrectly categorizes persons who commit any misdemeanor crime as low risk. And when we talk about the research on this, and I've actually been involved in this in Wisconsin as part of a criminal justice coordinating council and a grant through the National Institute of Corrections, who has all of these programs. So there's no need to reinvent a wheel on how you can successfully implement bail reform. It's all about risk of the offender. It is not in any way, in any of the objective evidence-based research, about a specific crime. So this bill just says all misdemeanors, from a disorderly conduct to sexual contact with a 15-year-old, are all crimes, and a whole bunch in between, are all crimes which, just by law, we're now going to say are low risk. Well, that refutes and is completely contrary to the research and the evidence, because each individual has to be evaluated on their own for their risk. You can have people that commit misdemeanors that are low risk. You can have people that commit misdemeanors who are medium or high risk. And a high risk individual is not only not going to appear in court, but they're also a public safety risk, either to the public at large or to specific individuals. That's the science. This also ignores objective risk assessment of the actor being the person arrested. So there's a whole process for how this can actually be done and is being done in many other states. And actually this creates, as the sheriff mentioned, unfairness for the community and the victims. So while our legislators, in a well-intentioned fashion, seek fairer judicial process for the perpetrators, as written, this bill throws fairness for the community and the victims to the side. And then again, there's a way that we can meet in the middle on this in a sufficient process. So there's some research and some links here for those of you that are interested to start to look and educate yourselves about bail reform. The National Institute of Corrections has a plethora of information about, and they're actually the ones who also grant fund criminal justice coordinating councils, which are made up of criminal justice entities across the spectrum. So you have harm reduction, you've got defense attorneys, you've got law enforcement, judges, all of those people coming together to work on these issues in a collaborative fashion. That's really how we get things done, I think, successfully. So you can go to these links, and there's some very lengthy reports that talk about the research on bail reform. Again, the research will tell you crime classes don't determine defendants. So you can't simply say all misdemeanors should not have bail because all those people are either low risk or we're categorizing them as low socioeconomic status, and they shouldn't sit in jail because they can't afford to pay. That's contrary to the research and the evidence-based findings. Validated risk assessment tools. Okay, so in many states, in the council that we worked on in Wisconsin, we were able to create a validated risk assessment tool that's based on a number of questions to best determine a person's likelihood to appear in court, which is obviously a very important component of that's why bail was created. We just attached a money aspect to it, and now we're kind of in a different dynamic. But what's their likelihood to appear in court, as well as assess the danger to the community or a specific victim if this person gets out prior to trial. And the research will tell you that there are three categories. Low, and everyone that's in the low risk category should get personal recognizance. The other thing that's interesting about this is that you could have what might otherwise be a higher level crime, but the offender might actually be low risk. So having a valid risk assessment tool is actually how we create fairness in the release and bail determinations. Those that come in as medium may get personal recognizance or some type of monitoring system to help them ensure that they're going to appear and make sure that they don't further endanger anyone else. And if you're a high-risk offender, in the research, that means you don't get out. You are either so likely not to appear in court or so much a danger to the public or a specific victim, there is nothing that can get you out of here until you appear for your trial. And so those are the three components. This bill only talks about misallocating classes of crimes and letting everyone out, contrary to the research. It has no component whatsoever for holding those that are a danger to others or that are likely not to appear, no component for holding them in custody. Yet that's what the research tells us. That's the evidence-based information. So that's where we are in disagreement, and we want you to be educated about that because ultimately this will affect the community, the business community, and community at large, and it will affect law enforcement because we will have no ability to keep these people from reoffending or endangering others or ensuring that they appear in court. Some other reference material for you. This is about a 112-page document, but the National Association of Pretrial Services Agencies, NAPSA.org, published in 2020, just last year, revised updates on standards for pretrial release. So this, again, is not new. This is current research and evidence-based information that should be incorporated, I think, into any future discussion about bail reform. Standard 1.2, bail should be individualized to a defendant's risk of failure to appear at scheduled court and risk to public safety. It is not an either-or proposition. Maximizing release. Release decisions via least restrictive means to assure appearance. I think all of us would agree on that. I don't want to see anyone sit in jail merely because they can't pay and they're a low-risk offender. I totally support that. My colleagues support that. But the and public safety part is not in this bill. And that is part of the research, okay? Again, maximizing public safety. And under their standard, the question is, will the defendant's release pose a significant risk of harm to a specific individual or to the public? In the bill as written, the only misdemeanor crime that is excluded from immediate release is domestic violence, likely because it's tied to other federal law, etc. But what the bill forgets is domestic violence restraining orders, harassment injunctions, stalking. all these other misdemeanor crimes that pose significant risk either to specific people or the public at large. So again, using a crime class to define a risk category is not an accurate use of the research. Standard 2.2 bail statute should include, again, presumption for non-financial release with the progression from release on one's own recognizance to non-financial release conditions reasonably assure court appearance and public safety. They want to exclude financial conditions as a standard and pretrial detention for the limited number of defendants who present an unmanageable risk to commit a dangerous or violent crime while on pretrial release or to willfully fail to appear at scheduled court appearances. This bill as written, because it's all misdemeanors require immediate arrest. Here's another example. I could be arrested for bail jumping. When a judge sets bail and gives me requirements, they might tell me, hey, you know, Chief Cebulski, as part of your bail condition, you can't have contact with Chief Otterness. I get out, I have contact with Chief Otterness. I violated my bail. A bail jumping warrant is issued, which is a misdemeanor. Upon my arrest and booking, I'm going to walk right back out the door. So it completely abrogates the judicial authority in setting bail. It almost just throws it to the side and makes it a useless proposition. Standard 4.4, validated risk assessment. Again, defendants should be classified in distinct risk and supervision categories based on the assessment scoring. And in bail reform research, that risk assessment is done by a non-law enforcement person. So while it is done at jail intake, you have someone who may be employed by the county, but is not a law enforcement person. Again, to create objectivity and objective use of the tool, they're asking the questions, they're then scoring the product based on that validated tool, and then the risk is assigned from there. From that point, they go to the judge. If it's low risk, they probably won't even go to the judge because we know that would be PR. If it's medium or high, those are the ones where judges then have to weigh in on these other factors. Okay, so how do we get to this point? Again, criminal justice coordinating councils are an excellent way to set up a collaborative approach to bail reform. There's a link in the presentation as well. That's part of the National Institute of Corrections. They do grant work on these. They provide technical assistance. As I said before, I've been part of this type of approach in Wisconsin for many years, both at the state level and as a chief in Beloit. And I think it would be an excellent approach for North Dakota to accomplish, I think, what the well-intentioned ideas are in this bill, while also addressing the adverse public safety issues that the current bill presents. I'm going to just check for questions. I think there was a couple sitting here, so let me just address that. Yes. Okay, good. So maybe we give Melissa the microphone and she can ask the questions, because you have them all, right, Melissa? Mm-hmm. And then we can alternate from there. Go ahead. Let's see what the question is.
Okay, so we'll start from the top.
Okay.
Thank you for your chamber update. In your opinion, what is the PD priority for ensuring the public feels safe in downtown?
Well, obviously, our whole community is important to us, but the downtown is the gem of Fargo. In addition to things of this nature, educating the public about these types of activities, we'll be enhancing our patrol footprint downtown. We have a new staffing plan that will be going into effect in March. That will allow us to put more officers out when it's busiest and also to concentrate in some of our areas such as the downtown to ensure public safety.
When the downtown businesses came together a couple months ago, anything changed from PD perspective?
I'll let Chief Cebulski answer the PD perspective, but what I would add to that is just that the sheriff's office has been working more closely with the police department at this point, and daily the police department will call over to our jail and ask them how much room we have for the day, and then that way they can prioritize who they come into contact with during the day to bring them in if they're causing regular problems for you guys downtown. So we've made that adjustment. In addition to that, I pushed really hard to get CARES funding used to add on to the jail, and we're doing that. That's going to start in February. There's definitely a need for that, mostly in the avenue of isolation in the jail. Our main issue at the jail, like I mentioned a couple times now, is when people are brought in, they have to be isolated for a period of time before they can move back into the general population, and that's caused some issues. That's why the Fargo police officers have had to cite and release some individuals, and so we're looking for a solution to that, and part of that is adding on to our booking area and adding more isolation cells so we can have more availability when officers bring those individuals in to resolve some of those regular individuals that you're dealing with.
I think that's sufficient. Did that answer that question? Yeah.
That's been the main thing that we've worked on together to try to come up with a solution.
Thank you. If this bill passes, will this have any impact on the jail?
I don't know that it would necessarily change too much at the jail because, as I mentioned earlier, 90% of the individuals that are arrested and brought there are making their bail or bond anyways. This obviously, if this bill was enacted, is people would be brought there and they'd be released on their own recognizance, so they wouldn't have to post that bail. So there might be just a little bit more room as far as people that are getting out. But because of the fact, like I mentioned earlier, 90% are making their bond anyways, I don't think it's going to have a huge impact.
Okay. Could you ask whether City Commission is in favor or against this bill?
So last night at the commission meeting, there was a discussion about legislative review, and I don't know how familiar, you may be more familiar as a business community, but the legislative process in North Dakota goes very, very fast. There's very little time to react at two bills that are proposed to committees vote, and then everything coming out of committee goes to the floor. So because of that process, it's almost impossible to be in front of it in terms of, okay, we see a bill. In fact, this particular bill came out on, we were made aware of it on Friday the 15th, and it was being presented to the committee on Monday, January 18th, actually a city holiday, day in which we would have actually been off, but weighed in on it because we realized what a significant public safety risk it was. So we are briefing our commission on legislation going forward, but again, the expedient way in which it's done doesn't really put them in a position to be totally informed about things that we may have subject matter expertise about. They may have a different opinion about, and that's a separate discussion. But certainly, as law enforcement professionals in our duties for public safety, we can't sit by and let something like this go through without at least weighing in on it from our subject matter expert position. If the commission decides something different later, that's totally in their venue. But we did have discussions with the mayor on this particular bill. But again, it was a very short turnaround. I think what actually would assist in that is if the legislative delegation created a broader coalition of people when they're working on bills that affect all of us in this fashion. As I commented before about the criminal justice coordinating perspective, that involved everyone at the front end. So we all could sit down at a table and hash all of these issues out to come to, I think, consensus on some well-intentioned ideas. We don't oppose that, but the issue is that we weren't even made aware of this until the 11th hour, and we had to react very quickly because I think we would all be remiss in our law enforcement duties if we just ignored it and let it go through and, well, I guess we'll just see what happens because we know what'll happen. Also, myself as a subject matter expert and experienced with this particular bail reform issue, I already know that it's in conflict with the research, which is also something that I think I would want to identify and at least educate the public on.
And if I could add to that just real quick, I very much agree with Chief Cebulski in the fact that both he and I and Chief Otterness are very open to meeting with legislators at any time and sitting down and coming up with a collaborative solution to this. That did not happen. And when things like that happen or occur, then it's hard for us to react. And really, sometimes our only option is to oppose things then, because we didn't come up with a solution that benefits everyone. And that didn't happen in this case.
So on that note, what steps can the businesses do to support you to either support or go against this bill?
Well, I just want to, well, we want you to be educated. So what can you do? I think look at some of the research, come to your own conclusions. The folks that are working on this bill are, you can go to legis.nd.gov, and you can see who the bill sponsors are. You can see what's being done with the bill. Those are discussions for you to have on your own volition. We're merely trying to provide you the information so that you are well informed to have those discussions. Again, I think all of us would be very interested in a collaborative approach to this issue because we don't disagree that there is an issue. I think it's just in how the issue is properly addressed to both ensure a fair system, but also to ensure public safety for everyone else. So I think it's really just do your research, work together collectively as your groups, and then have discussions with those elected officials.
And again, I would just echo what Chief Cebulski said. I mean, our intent with this was to be transparent. That's very important to us. That's how we gain trust with our community. And so we really just wanted to get the information out there, get it to you so that once you had it, you could then make a good, educated decision on how you wanted to respond. So
the next question is for you, Sheriff. Is there a specific number of offenses that automatically keeps an offender in jail?
And are they referring to misdemeanors, do you think? Okay. Could you ask me it one more time?
Is there a specific number of offenses that automatically keeps an offender in jail?
I don't really know specific offenses that they're asking. But of course, if they're asking in relation to misdemeanors, we're going to have those certain charges that I mentioned earlier that must appear, where the person can't get out immediately. The percentage of offenses that are committed or those offenses that are committed that are in relation to that, I don't have the exact number of that, so I don't know for sure.
Will PD patrol change and thus change collaboration with groups such as the BID and DCP?
I guess I don't know what they mean by change, but I think certainly one of our larger goals is to enhance our community and business partnerships. So again, I think a lot of those opportunities are presented with the change in our shift schedule and the different deployment of personnel. And we'll be utilizing our downtown resource officers in a different way as well to expand their presence both during the day and evening hours, which is something that we don't have now, and also during the weekend. So I think part of that staffing shift is going to help grow at least that downtown business relationship with not only DROs, but regular patrol staff as well.
Thank you. If this is passed, is there follow-up legislation that will further change the detention system? And will this set a precedent that further handcuffs law enforcement?
I think it would be hard to answer that one for sure. I mean, I'm not aware of any other, obviously we have the bills that were presented this year. I'm not aware of anything going forward right now after this session that would further do that. I'm hoping, much like we mentioned already this morning, that if there was further change that was going to take place after this legislative session, or the bills that we're aware of this time, that we could have that coalition effort to work on those going forward, and we wouldn't have any more surprises or instances like you were mentioning that would further handcuff us in discretionary efforts or how we do enforcement. So I'm not aware of any right now going ahead, and hopefully that wouldn't happen.
Excellent comment. And one other thing I guess I want to point out is that there are some folks that would say, hey, we need to act on this quickly because there could be pending litigation. Well, this is a large issue. You can't just do a corner cutter approach and hope it all works out in the end. And the fact that North Dakota, as a state, if they are taking a proactive approach to addressing bail reform, even just establishing a criminal justice coordinating council to further study and work this problem would likely negate that issue. So I think some folks feel pressured that they have to make a quick, well-intentioned decision because of that. And I think anyone just using common sense would recognize that something this large that affects so much across the board will not successfully be done in quick measure and does require a large collaborative coalition. So again, hopefully that's the approach that's taken. We'll see how things progress. Obviously, once things move out of the House, they cross over to the Senate and there's more discussion there as well.
Okay, looks like the last question here. Melissa, are you going to receive these slides to share with the community, or at a minimum, the link to these slides for DCP members and throughout the community to read?
Put yours on? Okay. We will post a slide presentation probably on our city website under the PD portion of the website. You got yours somewhere?
We would do the same on our sheriff's website as well, on Facebook. So, and certainly anyone can grab that information. We want to be transparent with it. We want people to have it so that, much like we did this morning, they're educated and going forward in how they view the bill.
All right, one more came through. Do you have one time? Thank you, both of you, for sharing this. How can we get ahead of these bills in the future as a community to either support or go against?
So as I said, it's really a quick process. It's certainly new for me, but we're learning quickly. That legislature website, legis.nd.gov, you can go on that website and you can go into the 67th Assembly, or now the 67th Senate as well, and look. There's an icon for committee hearings and for proposed bills. And I'm not sure how far out. Is it just a week still? Yeah.
So there, as you can imagine, there's a number of bills that are presented, and a lot of them. And how we get the information on the bills is every Friday we look to the next week and see what bills are coming up. That's really, because there are so many, that's really the way to kind of sift through them. And we've been kind of taking it a week at a time. So that's probably going to be your best thing. I mean, like I said, there's a lot of bills. So if you went in there and just started looking through, you probably missed some things that might be important to you. But I think if you go in there weekly and look at what's coming up the next week and study that might give you a good opportunity of what you'd want to look at and potentially educate yourself on.
Thank you.
Okay, thank you. I appreciate everyone's participation, those in the live stream audience and those here in person. Thanks to all of our business community partners, and again, Sheriff Johnner and Chief Otterness for being here today on this. And we look forward to working through these issues together. I'm sure this won't be the last issue that we have to tackle, so these relationships are important. Thank you, everyone, and have a good day.